Houston Wade recently declared bankruptcy after Wade was sued for defamation, lost in Kitsap County Superior Court, and after that court issued a $503,000 judgment against Wade for his false online statements. In that state proceeding, Wade was held in contempt and also, as Judge Hauser notes, lied under oath during the proceedings. As a result of this loss in state court, Wade filed for bankruptcy in an attempt to have that court judgment against him extinguished. Federal bankruptcy courts do extinguish debts held by debtors, but they are prohibited from extinguishing court judgments that were the result of malicious and willful action by debtors. Judge Dore of the Bankruptcy Court has already ruled that Houston Wade's defamation was malicious in a hearing for summary judgment.
Summary judgment is granted as to the malicious prong of Section 523A6. The first three elements of that prong, namely a wrongful act done intentionally which causes injury, were unquestionably determined in the judgment. The judgment provided that Mr. Wade published defamatory statements about Mr. Nelson. Those statements were false. Those statements were defamatory per se, and Mr. Nelson suffered $500,000 in damages. Those findings from the judgment established that Mr. Wade committed an identifiable and legally wrongful act against Mr. Nelson. Given that determination of wrongdoing, Mr. Wade cannot identify any cause or excuse that would be just.
Surprisingly, the judge has not yet found Wade's defamation to be willful, although he notes that is the only thing left to be shown for a summary judgment to be issued.
We would like to have an opportunity to elicit further discovery for a possible summary judgment motion solely on the willful element.
That's all that's left.
It is difficult to conceptualize somebody taking malicious action against somebody else without that action also being willful. Still, Judge Dore found that alone was not sufficient at the summary judgment stage to demonstrate willfulness, even though he found that the court record demonstrated maliciousness. As Wade's lawyer requested additional time for discovery, I would expect Nelson's lawyers will file an additional motion for summary judgment to demonstrate that Wade also acted willfully. And I think they will easily demonstrate Wade's willfulness from several angles. First, Wade continues to defame Bill Nelson in violation of the injunction against him by the Kitsap County Superior Court, which has made very clear that Wade and his statements were false and very damaging to Nelson. It couldn't be made any more clear the damage that he has done when he was issued a $503,000 judgment for that damage. Yet, Wade persists. That Wade continues his defamation even now is clear indication of his willfulness. Second, Wade's so-called news media blog, which was actually a Facebook page called the Bainbridge Island Bad List, detailed its reasoning for Wade's defamatory speech, which was to expose and shine a spotlight on the several individuals Wade targeted with that page. It is easily inferred that this attempt to shine a spotlight was done to damage reputation. Conducting business requires a good reputation, and businesses go to great lengths to avoid damage done to their reputations, even over issues that have nothing whatsoever to do with their product. Third, Wade's Bainbridge Island Bad List detailed specific goals to be achieved by its speech. For one of the several individuals, the desired goal of the speech and the condition for that speech to be removed was for the target of that speech to, quote, move out of our community. Forcing a person to leave their community and the place where they have built business relationships is clearly a harm to them, and this was clearly the kind of harm desired by Wade by his own admission. Fourth, Wade specifically sought the social and, by extension, business ostracizing of Bill Nelson. he instructed people to stay far away from Bill Nelson. Fifth, Wade even specifically sought for people to, as a result of being made aware by Wade of his false allegations in his defamatory remarks, that they cease giving money to Bill Nelson. This shows a willful attempt to damage Bill Nelson financially, as Wade was successful in doing, and as the judgment against Wade by the Kitsap County Superior Court demonstrates. Sixth, Wade demonstrates that even before the Bainbridge Island Bad List defamation, he sought to and took actions in furtherance of financially harming Bill Nelson to the point of bankruptcy. Houston Wade's willfulness is absolutely clear. It's my hope that Judge Dore will follow our law and not allow Wade's malicious and willful actions to be shielded from the accountability they deserve and as they were ordered by the Kitsap County Superior Court. To allow Wade's malicious attack of an individual to pass without recompense would only guarantee further malicious defamatory attacks against other individuals, as Mr. Wade has also made clear he will do. It would deny Bill Nelson the extraordinarily expensive due process he hard fought and won in our legal system that our tax money has established, a system where a civil society provides a method for good actors to defend themselves against the malicious among us. While most of the people we encounter are dishonest in some measure and can be malicious, Houston Wade is on an entirely different level. He is an extraordinarily voluminous liar with an extremely hateful character, and he routinely and purposefully uses lies to target people he disagrees with or does not like. While Wade routinely employs a variety of defamatory weapons against targets, including allegations of intent to murder, being a literal Nazi, or having a racist affiliation, and all of the like, the crown jewel in Wade's defamatory arsenal is the lie of child molestation or sexual child exploitation. Houston Wade fully understands why legal textbooks use this example as the ultimate form of defamation. It is precisely because of its power to maximize the damage to the intended target using mere words. While the entirety of Wade's evil and willful actions against others cannot be communicated to any judge or jury, they should not be required in this case for our law to be followed and for Wade's debt for this tiny portion of the harm that he has created to stand. While civil proceedings are not criminal, there is still a deterrent effect that is vital if we are to remain a civil society.